And good morning, 417 land. Welcome to second winter.
Yeah, no doubt.
We're moving into a second winter here. We're going to talk today about what to do when Social Security brings their own expert witnesses to your hearing, right after this.
I want to be your disability rep.
And we are back. So we've talked a lot about, bringing our own medical records and our own stuff, but Social Security can do that too.
They can, yeah. So in the hearing process itself, they can usually bring in a vocational expert, and we've talked about that some. Probably 95, 7, 8% of the hearings that I've had have had a vocational expert. A much smaller number have had medical experts. But they do bring those folks in, and they participate in the hearing as well.
And how does that usually go?
Yeah, so there's a couple things there. I mean, they will get in a record set ahead of time, and I'm always concerned about what they get for a record set. I don't ever get to know that, but they do get a record set ahead of time. The medical expert will look that over. And then, of course, in the hearing, they will take questions from the judge. They'll summarize the record, point out limitations. A lot of times they'll give an opinion as to what a person's able to do, despite their condition. So a couple areas that it's important for folks to watch out for, especially if you do your hearing on your own, is you always want to see what the medical expert's expertise really is.
Sure.
It sounds like a horror story, but I have seen gynecologists and pathologists contribute as medical experts on orthopedic issues. Yeah, and I'm sure you encounter this in your profession all the time, but some people think that a lawyer fits everything or a doctor fits everything. It's not always the case.
No, it's really not. People, like you said, they'll ask me all the time, about areas of law that I've never practiced in, I've never studied. I maybe had a class on it in law school 30 years ago, but it's not my area and I'm not the right person. I try to get them to the right person. But, but when I was practicing in the courtroom a lot more, whenever we did have an expert, you always got to get their curriculum vitae. That's available too?
Yeah. They put a resume into the record for folks with layman's terms. They put a resume into the record. You can object to it. They have to summarize their professional experience and how it relates. It's there, but most people aren't going to look at it, aren't going to understand it, aren't going to know if it's somebody who's qualified or not qualified. And honestly, if you're a gynecologist and you're doing this work for Social Security, you're probably not putting that out there front and center for folks to readily be able to recognize it.
This is probably a difficult question to answer, but how receptive are the judges to somebody challenging one of those experts saying, hey, listen, I understand they're a doctor, but this is not their area. I really don't think their opinion's qualified. Yeah,
it happens all the time.
Yeah.
So, I think the judges are pretty receptive to it. You have to have good reason. And that's the thing, if you're doing it on your own, you can't just say, that guy's a quack, because it's not going to go anywhere. But if you have a sound argument, it creates traction most of the time. The judge, especially in a Social Security hearing, they have 5 steps they use to determine disability. When you clear step 4, which is you can no longer go back to the work that you know how to do, when you move to step 5, there's a limited shift in the burden of proof. The judge has to establish that there are jobs that you can in fact go back to. So there's kind of an extra incentive to make sure that they dot the I's and cross the T's, even as it relates, retroactively in the hearing to the medical expert.
Now, is this medical expert that Social Security brings, are they testifying live or are they testifying via written record?
No, both. Traditionally, they testify live. Occasionally, they'll do interrogatories to that person. Same thing with the vocational experts. And of course, the interrogatories is where they send out written questions. The vocational or medical expert responds to the judge.
Under
the
oath.
Representative, the representative and or the client is able to ask additional questions or request a new hearing and get together and kind of cover those things. But they testify live during the hearing. Sometimes they do a good job, sometimes they don't. There are some conditions, and this is, of course, why it's important to hire somebody who knows the ropes.
Sure.
There are some conditions that they bring medical experts in to testify about that there's really no physical findings to support anything. And I'll give a great example. I have a client who's narcoleptic. Narcolepsy has basically no physical findings.
Yeah.
You can do as many exams as you want to do of that individual, and you're not going to find anything physically wrong with that person. And in fact, the Social Security regulations specifically say that. Had a judge bring in a medical expert. Everything's normal. He denied my gal. We went to the appeals council and they said, no, wait a minute. Your own rules say that there are no physical findings. So even though they bring in a medical expert, they're not above being questioned.
Right.
Their role is not above being questioned. Their need is not above being questioned.
Well, and you just said something real important there, but on appeal. And I think a lot of people in the legal world, in your world, which is the legal world too, don't understand that that trial, that first hearing, isn't necessarily the end.
Yeah, for sure. And with Social Security, we have an initial denial, a reconsideration denial. Then you go in front of an administrative law judge, then the appeals council, and then on to district court. There have been a couple cases that made it to the Supreme Court on Social Security issues.
Yep.
They were really interesting issues. They weren't just run-of-the-mill stuff.
Of course not.
But there's always another layer of appeal, and the judge has got additional responsibilities, things that she has to do, and if they fail to do those, then you move on. And that's kind of where the real problem, I think, with a lot of clients come in, is people go in front of a judge and they think, well, that's it. The judge said that's the final word, that's the final authority. These folks make mistakes too.
Sure.
When they want to deny you, you can look back through that decision and you can see where things are borderline taken out of context, especially about your physical functioning at home, your activities of daily living. But you can see things that are kind of a stretch, and a lot of people just let that go.
Yeah.
And when you hire somebody whose job it is to question them, it ends up with a much better result a lot of times.
Almost always. Hey, if you have questions for Roy, or you'd like to hire him, or just have him take a look over your case, maybe it didn't go your way and you'd like to have some better eyes on it, give him a call. His number's on the screen, 417-812-6698. And we'll be back next Wednesday. See you then.
I want to be your disability rep.